Hi, my name is David Fraser. I'm an internet and privacy lawyer with McGuinness Cooper in Canada. Today I'd like to talk about and provide some general information about the use of surveillance cameras by businesses in Canada. Starting off with a bit of a usual disclaimer. So this is a general overview. It's intended to be educational and informational. Canadian privacy law is actually pretty complicated, and it's an area of law that's regularly changing. And so this information might become out of date relatively quickly. And so if you ever have a specific legal question or need to know how the law applies to a particular situation, you really need to seek qualified legal advice. Now, these opinions are my own and should not be attributed to anybody else, including my firm or its clients. And again, this only applies in Canada. Different laws exist in different jurisdictions. And so this is intended to be talking about essentially the high watermark of the regulation of these devices across Canada. So I'm going to talk about their use by businesses, turn our minds to kind of what law applies, and then within that law, what are the rules and what are the best practices? And finally, talk about disclosures to law enforcement, which are relatively commonly made, and the law and the rules associated with that are not all that well understood. So what are the legal principles involved? And again, what we're talking about here is the overt use of CCTV by businesses. There are different rules and different analytical frameworks that one would need to apply for the use of cameras in workplaces. There are different rules for covert or hidden cameras, different rules involving the public sector generally, and then also different rules about the police. We also have circumstances where the use of CCTV may be required by law. So, for example, in casinos, and those would have specific separate rules. And then also personal use. So your video doorbell or using a camera around your house to protect your property, those are under completely different rules. So again, we're talking about the use of cameras by businesses. You walk into a gas station, you walk into a grocery store, you walk into a shopping mall, you certainly go to use a bank machine, and you're going to see cameras all over the place. This is about the rules that apply to those cameras. So what are the legal principles? One thing that's really important that people need to know, and that businesses in particular need to know, is that a person's image is their personal information. And by businesses, that collection is regulated, even if it's in public. I sometimes hear people say, well, it's in a public place, you have no expectation of privacy, and that may be true in some circumstances. But Canadian privacy regulation, which applies to businesses, treat that as personal information, and whether it's in public does not bear on whether or not the activities related to their collection, use, or disclosure is regulated. So within this regulatory framework, what that says is businesses have to identify the reasonable purposes for which they collect personal information. The rules say they need to obtain consent for the collection of that personal information. They need to limit what personal information is collected in the first place and limit how it is used. Businesses can only retain personal information for as long as necessary for those purposes. Businesses need to be transparent and accountable about their collection, use, and disclosure of personal information. Now, Canadian regulators have provided a fair amount of guidance, and I would suggest you take a look at it, and I'll include a link in the description below. So the Federal Privacy Commissioner, the Information and Privacy Commissioner of Alberta, and the Information and Privacy Commissioner of British Columbia have produced guidance for businesses on using overt video surveillance. They also have guidance on covert video surveillance, and they've also provided some guidance to police on their use of surveillance cameras. And so this is a useful, interesting document that talks about and essentially covers the high watermark about the law among those three jurisdictions. So what do you need to do? What do businesses need to do? So businesses need to determine and document the purpose. Why use cameras in the first place? It has gotten much easier to make this, to decide, oh, well, I'm going to install cameras in my store, in my operations, around my building, because cameras have gotten a whole lot cheaper than they were before. managing the information coming out of those cameras has gotten a whole lot cheaper than it ever was before. And cameras have gotten a whole lot smaller than they ever were before. So there often is a much greater tendency to just kind of buy a bunch of cameras and put them up. But the business really needs to first determine and document the purpose, and then figure out, is that purpose reasonable and justifiable? Then they need to think, is there a less privacy invasive means to accomplish that purpose? They need to limit what's captured. They need to limit where it's captured, which I think links pretty closely to, is there a less privacy invasive means of accomplishing this purpose? They need to think about, does it need to be recorded? What is in some instances, observing an entrance, for example, by a security guard doesn't require that be recorded. But if the cameras are up for a slightly different purpose, recording may be an important part of it. But if it is recorded, how long should those recordings be kept? Who needs to have access to those recordings? And then you need to think about signage, and we'll get into why. So how do you determine reasonableness and why? Well, at least in PIPEDA, the Federal Personal Information Protection and Electronic Documents Act, has as a gatekeeper, a baseline function requirement that an organization may collect, use, or disclose personal information only for purposes that a reasonable person would consider are appropriate in the circumstances. And so it has to be reasonable in the circumstances. It has to be to address a reasonable purpose for that particular business. And so once you've met that reasonableness threshold, every organization under Canadian privacy law, at least under the federal statute, the second principle in the statute is called identifying purposes. And this is drawn from the Canadian Standards Association Model Code for the Protection of Personal Information, which essentially is fair information practices. Now, Principle 2 says the purposes for which personal information is collected shall be identified by the organization at or before the time the information is collected. And what this means is the organization has to identify internally itself, what are the purposes? What are we doing this for? Is this for safety? Is this for security? Are we dealing with concerns about theft? Are we dealing with concerns about vandalism? What are the purposes this is intended to address? And you need to do that internally in order to inform all the analysis that I'm going to talk about. But you also need to identify that externally, because identifying purposes is the foundation for consent. So Principle 3 from the Canadian Standards Association Model Code says the knowledge and consent of the individual are required for the collection, use, or disclosure of personal information. And the CSA code then says, except where inappropriate, but now that it's in a law, you essentially have to scratch that out. The federal court has said that all the consent exceptions are contained in the body of the statute. And so businesses don't get to determine where it's inappropriate to obtain, to not get consent. And so you always have to have consent to collect, use, or disclose personal information if you're a business, unless you fit within a consent exception. And it also says the form of consent is dependent upon the sensitivity of the information. Now, when it comes to the use of CCTV and surveillance cameras, businesses mostly rely on implied consent. That if you have identified to individuals entering your premises that surveillance cameras are in place, and you identify the purposes, therefore satisfy Principle 2, then you have implied consent from those individuals when they enter the premises with that particular knowledge. Another critical principle is Principle 4, called limiting collection. The collection of personal information shall be limited by that which is necessary for the purposes identified by the organization. And information shall be collected by fair and lawful means. So when using CCTV, you can only collect the information that's reasonably necessary for the purpose that you've identified. Again, coming back to, is it to protect against theft? Is it to protect against vandalism? You really need to minimize the information you're collecting, and what information you're collecting has to be tied back to those purposes you've identified. And then Principle 5 essentially says, kind of brings it all together, you have to identify the purposes. You have to get consent for the purposes. You can only collect the information that's necessary for those purposes. And then you can only use, disclose, and retain the information for those purposes. So Principle 5 says, personal information shall not be used or disclosed for purposes other than those for which it was collected, except with the consent of the individual, so if you get further consent, or as required or permitted by law. And the personal information shall only be retained as long as necessary for the fulfillment of those purposes. If it's no longer necessary for those purposes, it can't be retained. We also have Principle 6 called accuracy, which says personal information shall be as accurate, complete, and up-to-date as is necessary for the purposes for which it is to be used. Now, when it comes to the use of surveillance cameras, this likely comes into play in terms of the placement of the cameras to make sure that the information that you're collecting is accurate and not misleading. You don't want to have sections that are cut off that could lead to inaccurate or incomplete information. You want to make sure that whatever they capture is going to be accurate and usable. Principle 7, called safeguards. This says that personal information shall be protected by security safeguards appropriate to the sensitivity of the information. And so this means that any information collected by CCTV has to be protected, has to be safeguarded. And the CSA Model Code specifically says protected against loss or theft, as well as unauthorized access, disclosure, copying, use, or modification. So you'd have to make sure that only people who have a need to know that footage are the ones who have access to it, and to prevent anybody who doesn't have a need to know within the organization or outside the organization from having access to it. Principle 8 is individual access, and I don't think many businesses turn their mind to this particular question, but individuals have a general right of access to any personal information subject to some exceptions that the organization has collected about them, and they also have a right to understand how it's been used. And so Principle 9 says, upon request, an individual shall be informed of the existence, use, and disclosure of his or her personal information, and shall be given access to that information. An individual shall be able to challenge the accuracy and completeness of the information and have it amended as appropriate. So there's no carve-out to this right of access for CCTV. And so if an individual says, I was in your store at this particular time and I would like a copy of the camera footage of me in your store at that particular time, it has to be provided, subject to third-party privacy rights and things like that. If you ever deal with that, you're probably going to want to seek specific advice because, for example, camera usage might, in fact, the disclosure of the camera images could compromise the security of the operation, those sorts of things. Now, an organization can charge a fee, but it has to be reasonable. And I can imagine it could be quite high, since a whole bunch of footage would have to be gone through and chopped up and edited and possibly redacted in order to provide that individual with their access right. So let's talk a bit about consent and how these things are generally kind of played out in Canada. It's not uncommon to go into a store and see a sign like this one, "Smile, you're on camera." And that is not good enough. You'll recall that an organization has to identify the purposes for which personal information is collected, and they have to get consent. And so one really needs much better signage on the perimeters of a property and at the doors of a property before their image is captured, explaining to them that surveillance cameras are in use, explaining to them exactly what the purposes are, and also explaining and providing information about who is operating that particular service so that the individual can exercise their access right if they want to. And if you don't have adequate signage and you don't identify the purposes adequately, you're not getting adequate consent and you're going to be offside our legislation. So on this slide is an example of a sign that I saw in England a number of years ago, and it really is a good example of all the information that needs to be on a sign in order to adequately identify purposes and obtain consent. So in a nutshell, a business, in order to use surveillance cameras, that purpose has to be reasonable. They need to identify those purposes, and those purposes have to be reasonable in all of the circumstances. It has to be necessary. Information can't be collected willy-nilly, and depending upon the circumstances and where the cameras are placed, there is a question of proportionality. Is this in fact necessary to achieve that reasonable purpose? Are there other things that could be done that could be less intrusive with respect to informational privacy? Some of those measures are kind of cameras that are more visible or more obvious, or cameras that are only in public places or publicly accessible places, or cameras where that are not observed and the recordings are overwritten after one day if there's no incidents. There are so many different things that could be done in order to make it kind of less privacy intrusive. And that privacy intrusion ultimately has to be proportional. Is the effect on privacy proportional to the legitimate benefit from the use of the technology? And then at the end of the day, a business needs to give notice of all of those purposes and has to get consent. Now, finally, one often sees on the TV news or kind of Crime Stopper ads and things like that, surveillance cameras, surveillance footage from, let's say, retail operations that are being publicly broadcast in order to find somebody who is a suspect in a crime or things like that. And so when that happens, that is a disclosure of information, personal information, from the organization, from the business to law enforcement. And there are particular rules that apply to that. And in many cases, businesses aren't aware of what those rules are, and law enforcement don't care. PIPEDA and privacy laws are not their area of expertise by any means. And so they regularly ask for businesses to do something that will cause those businesses to break the law. Now, there's in fact a big difference between a business reporting a crime to the police and giving information like CCTV footage as part of that report, on one hand, and then when the police ask for it and if the business just hands it over. So Section 7 is where most of the exceptions to the consent principle. And Section 7 sub 3 paragraph D allows the voluntary disclosure of personal information without the consent of the individuals to a government institution, like a police agency, if the business believes that the information relates to a contravention of the law. But it has to be on the initiative of the organization. It can't be on request. This consent exception only applies if it is on the initiative of the organization. They are voluntarily handing it over, usually as part of a report. They want to report a shoplifter or a robbery or a theft or vandalism, and here is the relevant footage relating to an offense that they have suffered. But if the police ever come knocking on a business's door, the rules are very different. There was a provision, still is there, Section 7.3, paragraph C.1, that has been essentially rendered inoperative by a case from the Supreme Court of Canada called R. and Spencer. The statute refers to police requests where they identify their lawful authority to obtain the data, but the Supreme Court of Canada says this has to be a specific law that authorizes the collection by the police and the disclosure by the business or a court order. And so essentially what we're left with is when the police go to a business asking for CCTV footage, it is unlawful for the business to disclose it unless the cops have a warrant, usually in the form of a production order in Canada, that would permit them to collect the information and authorize the organization to disclose it to the police, because there's a specific provision related to court orders. So at the end of the day, in Canada, we have a mosaic of privacy laws, or a mess of privacy laws, that leave us with different rules for workplaces, that leave us with different circumstances related to covert or hidden CCTV use. The public sector is subject to their own set of laws. The police are regulated by those laws, but also by the common law of policing, also by the Charter of Rights and Freedoms. We also have laws that in some cases require the use of surveillance cameras. Casinos are the best example that I can think of. And then we also have different rules related to personal use. So what I've been talking about, while some of the principles may come into play in other circumstances, I've been principally talking about the use of cameras by businesses, usually retail organizations, banks, gas stations, and things like that. Just a final note, businesses should not record audio. So when a business thinks about putting up CCTV cameras for security purposes, in some instances, those camera systems might have the ability to record audio. My general advice is to not do that. So if you don't follow the rules exactly, you might find yourself offside for the use of video only, and you'd be only offside our kind of federal privacy regulations or the provincial privacy regulations that apply to your organization. But the recording of audio relates to the criminal code, the criminal law of Canada. Eavesdropping or recording a private conversation is a criminal offense. And there's a serious question whether a sign on the door would be enough to get the necessary consent. So the stakes are so much higher under Canadian law when it comes to collecting audio that one would need to tread extremely carefully before enabling audio recording features on a surveillance system. So hopefully this has been of interest and has been an educational overview of the law in Canada related to the use of surveillance cameras by Canadian businesses. Thanks so much for watching, and stay tuned for more Canadian privacy content on this channel.